My will document is 20 years old. It's probably fine, right? My name is Philip Bruce. I'm an estate planning attorney with Stone Arch Law Office here in Minnesota. John came up to me, and John was asking what I did for a living, and I said that I'm an estate planning attorney. I do wills and trusts for folks. And he said, oh, we've had a will for about 20 years. It makes us feel good that we have it. And I never want to push too hard with folks. I don't want to cause panic. I don't like people feeling fear. But that was disconcerting to me. And the reason is a will is a court document. You don't want to submit a 20-year-old court document for anything. Think of all the things that have changed in the past 20 years. And I am talking about things in your life, your relationships, the ages of your kids or your other family members, the people who would manage your estate. Does that change over a 20-year period? Probably, but let's just assume that it did not for a second. The best practices in the court system have changed. The order in which we file things electronically now for probates. Wills, again, they control probate. It's a court document. We used to send everything by mail with stamps, you know. All these things have changed. People have email addresses now and passwords. There's all this other stuff. We do not want to submit a 20-year-old court document, and that's what a will is. So my advice to you, go back to the attorney who drafted your will, or if you have another attorney you trust and with whom you'd like to work, get it redone about every 10 years. That's really a good rule of thumb. They're just stale, they're old. Do your family a favor, rewrite the will every 10 years or so. Here's one thing you might want to consider. This other tool called a revocable trust or a living trust. I've talked about this in other videos. This is the family thing that we create, where if we get your stuff into this thing, we can control it with a private family agreement called a trust agreement. Private agreements don't need a judge's help, so we can just administer the estate court-free. And because this thing, by default, doesn't really go to court unless something goes really wrong. But by default, but generally speaking, they don't need a judge, they don't need the court system, they don't need probate. We can let these go a little bit longer. I usually tell folks rewrite your revocable trust plan about every 20 years or so. That doesn't mean don't check in on it. You know, your life changes, your people change, your priorities change, your values change. So you got to keep up on that. But by virtue of it just getting stale, it's a good 20-year plan. Any questions on any of this, obviously, give us a call or certainly do shoot us an email.